Broadcasting from the business capital of the world, this is the Podcast Business News Network. Welcome back, everybody. If you're ever faced with having to go to trial, especially with a case that involves some personal injury, I'm going to say it's rhetorical. You want to win your case. What are some of the ways you can do that? Obviously, pick the right attorney, but it goes deeper than that. And we're going to talk about the 10 ways to win your case at trial. And this gentleman here today is going to walk that journey with us. He has won millions and millions of dollars for his clients. He is tenacious, successful, one of the top trial attorneys in the state of Maryland, and he is back with us. Always great to have him here. Learn so much every time we talk to Paul D. Bekman, who's our Diamond of the Decade. Welcome back, Paul. How you doing?
Doing great, Steve. Good to see you.
Good to see you too. This intrigues me. We're going to hit up all 10 here. And this is partly how you operate as a trial lawyer, but also just in general, things that need to be kept in mind. So where do we begin here?
Well, we begin with the first step, which I will call the first step. People ask me all the time, I lecture all over about trying cases and how to win your case at trial. And I'm asked all the time, Paul, you've gotten a lot of $1 million verdicts. How do you get $1 million verdict? And I say to them, it's very simple. You take a $5 million case and you screw it up. That's how you get $1 million verdict.
That's $1 million. Right there.
$1 million.
Yeah.
But let's go in and let's talk about 10 ways for you to win your case at trial. Number one, and everybody knows this, the Boy Scout motto, be prepared. The trial of a case is 95% preparation and 5% skill. If you get your case prepared the way it should be prepared, then you will win your case at trial. And that is number one. Do not leave a stone unturned. Make sure you have everything ready to go, all your witnesses, all your experts, all your arguments, and you will 9 times out of 10, win your case. So number one, be prepared.
I want to just jump on that topic for just a split second. Do you find, Paul, when you go to trial, you've got so much material that you don't even get to, but it's in your back pocket just in case you need it?
Yep. There are times, Steve, when you have something that's really, really significant. And that can be the key to the case. I've always said that you don't have to kill the opposition 6 times. All you have to do is kill them once and find the main issue in the case that will help you persuade the jury that you're right. And we're going to get to that in a couple of minutes because I'm going to show you, and those who are listening and watching, a piece of demonstrative evidence that will explain exactly what I'm talking about.
Sure.
But let's move on. Number 2, get the right lawyer if you're going to go to court. There are thousands, in essence, millions of lawyers across the United States, but there are very few lawyers who are actually what I'm going to call trial lawyers. There are a lot of lawyers that sit in their office, they never go into court, they settle all their cases, and what I find in that circumstance is they are sacrificing their good cases by settling good cases instead of settling marginal cases and going to trial with good cases. That's where you're going to get the good result. Good liability, good damages, direct causation, serious injury, or God forbid, death. That's the case you want to try. If you have a lawyer who just sits in his office and settles everything, everybody's going to know. Defense counsel is going to know, and insurance carriers are going to know. This guy doesn't go, or this gal does not go into court to try the case. And you get your reputation as a settler. So don't be afraid to go out there and try your case.
And I'll bet, Paul, even in those situations, everybody knows everybody in the courthouse. They know everybody's MO. Whether they're slinging things that aren't true, they know. So if you hire that attorney that isn't really in the trenches and just sits back, they're going to know and they're already prepared against him because they know he's not doing his homework.
You're right, 100%. And that's why when you go into court, you've got to develop your theme. What is your theme? What is the nature of your case? In a malpractice case, somebody goes in and they have a CAT scan because they're elderly and they lost weight. They suspect, primary doctor says, look, I think we ought to get a CAT scan. Don't know for sure, but let's get a CAT scan and let's see what it shows. Goes to get a CAT scan. And the CAT scan is read as normal. There's nothing wrong. Nothing wrong with the kidneys in particular. And there's great relief when you find out the results are okay. No problem. But what we deal with here is something that is very persuasive in any case, and that is what's called demonstrative evidence. Demonstrative evidence is evidence that you can see, you can touch, you can feel, as opposed to somebody talking on the stand and explaining something that may just go over everybody's head. So you want to keep it simple and you want to keep it clear. So let's take this situation. You have somebody who is elderly, they've lost weight, the primary care doctor sends them to the radiology office. Let's get a CAT scan. They do a CAT scan. It's read as normal. But unfortunately, it's not read right. And when you do your work and you do your homework and you get that CAT scan, lo and behold, you get it reviewed by a very effective, experienced radiologist who says there's a serious problem here. There is a tumor on the right kidney and it was missed. So how do you do that? How do you explain to the jury about that? Well, you use demonstrative evidence. Statistics show our general population, 75% of us, I'm one of them, learn by what they see, as opposed to 25% that are auditory, that learn by what they hear. So here we have a situation, and I'll show you this CT scan of gentleman's kidney. And here it is. You can see it a long way away. There are two kidneys, one over here on the right, one on the left. Okay. So during the course of this case, what I did was I took the deposition of the defense expert who was going to say there was nothing wrong. Well, I brought out this CAT scan. There are about 16 different slides. I brought this one out and I said, doctor, can you identify if there's something wrong, something abnormal when you look at a CAT scan, let's say of the kidney? Yes. And would you be able to identify if there is something unusual or wrong or out of order by looking at this kidney? He says, yes, I could do that. I said, well, take a look at this kidney. He said, okay. And do you see something that's abnormal? Yes. Could you take this blue pen that I'm going to show you and circle this? Yes, I can. So here we have it. Here is the circle in blue ink by the defense expert of a 2.4 centimeter growth on the kidney.
Unbelievable. And by the way, for anybody that is listening to this and not seeing it, I'm not being facetious, but you could ask a 10-year-old, do you see something, a difference between these two things, shapes? You don't have to even tell them that it's, kidneys. There's no question that there's a dark, call it mass, inside the left kidney. So that, in that case, Paul, the medical practitioner let that go.
Yeah, it was misread. It was read as normal, and it was not.
Wow.
And 2 years went by, and another CAT scan was done, and it was double that size, and he died 6 weeks later. All of which could have been prevented by making the correct diagnosis of this large tumor in the kidney.
Wow.
And this is where a lawyer, in a tip number 4, converts the complex to the simple. The 10-year-old that you're talking about, a 10-year-old could do that. When I showed this to the jury, the case was over. There was no doubt in my mind that they got it. And that's what a lawyer's job is. You don't have to make 6 different explanations about what happened. You've got one. You focus in on the main issue and you hit that over the fence. And that's what it takes to win a case. You have direction and you have your theory and you can prove it, and you can prove it very clearly. They'll see this in cross-examination. They'll see it in direct examination. They'll see it in a closing argument, and they won't forget it. And that's why there was a huge verdict in this case, unfortunately, for this gentleman who had died because he was misdiagnosed. They missed it. That's what.
Final question on that point. The medical professional that you were questioning, was that the doctor that originally missed it, or you brought an expert or somebody else there to?
This was the defense expert. Can you imagine?
My.
Expert testifying for the defense. So he gave me the case. I had a very fine radiologist, one of the finest in the country, testify that was there. He wasn't in the courtroom. The other doctor wasn't when he testified, but I took his deposition and I subpoenaed him and I had him nailed. And that won the case. There's no question about it. Focus in on the main issue in the case and you will win it. Okay. Now, have I overstated the case? This is a danger for everybody. You should understate the case and not overstate the case. Be factual. Be direct. Don't exaggerate things. Tell it the way it is. And a jury is going to respect that from a lawyer who knows what he or she is doing. So having the attention of the jury, and the jury knows that you are sincere about this case, is going to help you win the case.
I love that point, and that, I believe, applies to life in general in all situations. Keep it simple. Stick to the facts. The facts don't lie. Many attorneys will go in and, dog and pony show and throw things out there. Like you said, the jury has limited attention. They're visual. Excuse me. Just give them the information. That's it. Always leave them wanting more. I'm a believer in that as well.
Next tip. Have I lost my credibility? Which should never happen. Your credibility is the most important thing that you have in the trial of a case. There may be something in your case that is harmful. What I call that is deflate the bomb. Explain in your opening statement about a problem that might exist, a prior injury, the fact that your client may have been followed and they took movies of him. And that happens all the time. Person may have had a conviction for something. You explain it in your opening statement because there is an explanation. It may not be totally justified, but there is a reasonable explanation for something that may be harmful to your case. Don't let the other side bring it up because, Steve, what the jury's going to think is you're concealing something. And your credibility, lawyer, is the most important thing that you own in this trial. So deflate the bomb and do it in your opening statement because the jury will never forget it. Okay. In terms of questioning, okay, the questioning is on cross-examination. Don't ask open-ended questions. What you want to do in cross-examining a witness is to use what are called leading questions to the witness. And you're going to know the answer to these questions because you've already taken the deposition of that witness, whether it's a lay witness or an expert witness before trial. You know what they're going to say. Isn't it true, Mr. Harper? Wouldn't you agree, Mr. Harper? Isn't it a fair statement to say, Mr. Harper? Isn't it accurate to say, Mr. Harper? Knowing that the answer is going to be yes. And when the answer is no, you say, well, do you remember when you gave a deposition in this case? Yes. And do you remember where you raised your hand and you said you were going to swear to tell the truth under oath, under penalties of perjury, et cetera, et cetera. So you got them nailed. Leading questions on cross-examination. not open-ended questions. And sometimes the best cross-examination is no cross-examination. Some lawyers just can't help themselves about asking questions which may be irrelevant, immaterial, and not have any basis in fact, and can just divert the jury away from where they should be. So sometimes the best cross-examination is none. Listen to the witness. Don't sit down there taking notes. Listen your notes. Listen to what the witness is saying when they testify. And you can then repeat what they have said, and they may not have realized that what they said was inaccurate or different than what they had said previously. So you have to be on your toes. Don't forget that sometimes the power of the understatement is greater than the power of the overstatement. The person who's horribly injured, and you have them on the stand, and they are explaining their injury, they're going to say, you know, the doctors really helped me. The doctors did their best to help me. I know that there was a lot of judgment involved in deciding what to do, and they did the best that they could for me. But I still have these problems, X, Y, Z, A, B, C, D. That makes an impression of somebody who is not just trying to say, woe is me, I'm horribly injured. The power of the understatement is stronger than the power of the understatement.
And right there, in my mind, and we've got about 4 minutes or so left. I want to see if we get all these.
We're almost done.
The understatement, Paul, adds credibility to that person.
It absolutely does. There's no question. So here's another thing that you may want to think about, and that's save the clincher for rebuttal. If you go first and you close and the other side then closes, you have the last word. That is, the plaintiff has the last word. And you may have something that the defense just totally overlooked that can make every difference in the case. Defense says the plaintiff never got this medication that he said that he got. There's nothing in here that says that he got this medication that he says was the cause of his problem. And then you get up in rebuttal and you say, it's very interesting that the defense has said that the plaintiff did not get this medication, but we have here the bill that he got for this medication that he paid for. Killer, clincher, left for argument. And that can help you win your case. One other thing that, real quick, sometimes people have a pre-existing condition and it's aggravated and it's made worse. And the basic law around the country is that if somebody is susceptible to an injury or has a pre-existing condition, but a negligent act aggravates it and makes it worse, you are entitled to recover for that making it worse. And a lot of lawyers are afraid of this. Oh, he's got a pre-existing condition. He's got, he's very, very susceptible. Use it as a knife, okay, that you can put in, because the court's going to instruct the jury that you take the person as you find them. And if you cause an injury due to negligence that worsens their condition, the plaintiff is entitled to recover for that.
Key words here: worsens their condition.
Correct.
Wow.
So those are some helpful hints, hopefully, that people will think about when they talk to their lawyer about how the case is going to be tried.
Fascinating. As you're speaking, Paul, in my mind, I'm playing every courtroom TV, movie, drama I've ever seen. And I'm seeing pieces of them there. On the, I call it the zinger, the last one where you have the last word, that you'll have that opportunity, correct?
Save the clincher for rebuttal.
Yeah. Has there been times where you got surprised by something somebody else said?
It happens all the time. And sometimes it's right and sometimes it's wrong. So you've got to be prepared to answer it because you have the last word when you bring the case.
I have to imagine the amount of material that you and your colleagues, your team, have put together just going into a case, because I'm all about preparation as well. And sometimes it's planned spontaneity. You already planned everything out. You've got everything you need, but you never know where they're going to go. So I have to imagine volumes of paper, thoughts, evidence, everything that if they say something, oh, well, I've got this bill right here. It seems that if there's the top 3 things that we're discussing here out of the 10 ways to win your case at trial, preparation is right there.
You're right, Steve. The Boy Scout motto, let's go back to it. Be prepared.
Yeah. Wonderful talking with you, Paul. How do we find you? How do we connect with you?
Well, this is a world we live in. We're in the Google world. You can find out all about a lawyer or anybody today by Googling them. It's Paul D. Bekman, Bekman. I'm a lawyer in Baltimore, Maryland. I've been practicing for a long time. I've tried a lot of cases. You Google me, you'll find out all about me and what I have done and why I really enjoy the work that I do, which is helping people who may have been hurt, damaged, or seriously injured.
I appreciate you. I appreciate all the information today. Most importantly, your clarity is just, there's nothing to compare it to. I really believe that's your secret weapon, among other things. And I appreciate that. Thanks for being here today.
Great to see you, Steve. Thanks.
You too, Paul. We'll be right back. Broadcasting from the business capital of the world, this is the Podcast Business News Network.
Adopt US Kids presents Multiple Choice Parenting.
Your daughter just had her first breakup. Do you A, put yourself in her shoes?
How could he do this to you? And for Sheila, she has split ends.
B, console her?
Oh, sweetie, this is going to happen a lot. 4, maybe 5 more times before you get married.
C, take charge?
Got to get this all straightened out. Give a little talking to, man to man, mano a mano. Hey, Steve! Is now a good time? No? Okay, no problem. Bye.
Or D, help her find a new boyfriend?
I know a great place to meet boys. The internet. Nice, single boys. Never mind. How about some ice cream?
As a parent, there are no perfect answers. But you don't have to be perfect to be a perfect parent. Thousands of teens in foster care will love you just the same.
For more information on how you can adopt, visit adoptuskids.org. A public service announcement from the U.S. Department of Health and Human Services, Adopt U.S. Kids, and the Ad Council.